Welcome to The Explainer. Now, if you love untangling complex mysteries where fundamental human rights collide head-on, well, you're in the exact right place today. We're going to unpack a high-stakes constitutional clash that made its way all the way to the Constitutional Court of South Africa. It's a fascinating case, really, because it forces us to ask a very difficult question. How exactly does a newly democratic society balance the absolute, undeniable necessity of free speech with the very real need to protect its citizens from harmful, divisive broadcasts? It's a tightrope walk. So let's dive right into it.
Here is our roadmap for today. We'll start with the controversial broadcast itself, look at the specific broadcasting code it allegedly violated, examine the free speech dilemma under the Constitution, break down the Constitutional Court's analysis, and finally, reveal the final verdict.
Part 1. The controversial broadcast, or the inciting incident. Every great legal battle begins with a spark. So let's take an objective look at the event that set this whole chain in motion.
Back in May of 1998, there was a community radio station called Radio 786, which was run by the Islamic Unity Convention. They aired a program titled Zionism and Israel, an in-depth analysis. Just weeks later, a formal complaint was lodged, and that triggered an absolute massive procedural and constitutional battle. And, true to the usual speed of the legal system, it actually took until April 2001 for a high court to make a mere procedural ruling, which completely sidestepped the actual constitutional question. But because the stakes here were just so incredibly high and crucial to the public interest, the case was finally fast-tracked directly to the Constitutional Court of South Africa in April 2002.
To really understand the gravity of this case, we have to look at the facts of the broadcast itself. During the program, they featured an interview with a Dr. Yaqub Zaki. On air, Dr. Zaki questioned the legitimacy of the State of Israel and Zionism as a political ideology. He also went on to assert that Jewish people were not gassed in concentration camps during the Second World War, but rather died of infectious diseases like typhus, claiming that only 1 million Jews had died. Following this broadcast, the South African Jewish Board of Deputies lodged a formal complaint. They argued that these statements explicitly violated the country's broadcasting rules because they prejudice relations between sections of the population, specifically between Jews and other communities.
Part 2. The Broadcasting Code and the Rule in Question. So the complaint was filed, but what exactly was the specific legal hurdle right at the center of this dispute?
The board based their entire complaint on Clause 2A of the Code of Conduct for Broadcasting Services. The code basically stated that broadcasting licensees shall not broadcast any material which is, and I quote, likely to prejudice relations between sections of the population. Now, what's really interesting here is just how incredibly broad those specific words are. I mean, think about it. The Islamic Unity Convention argued that this phrasing was so wide, so unbelievably vague, that it was actually unconstitutional.
Part 3. The free speech dilemma and the constitutional right. This brings us right to the heavyweights in the ring.
In one corner, we have that restrictive broadcasting code aimed at maintaining social harmony. And in the other, we have the fiercely protective South African Constitution. The real crux of this clash lies in Section 16 of the Constitution, which is neatly split into two distinct parts. Section 16.1 offers this incredibly broad protection for freedom of expression. It explicitly guarantees the freedom of the press and other media, and the freedom to receive or impart information and ideas. But we all know freedom of speech isn't absolute, right? So, Section 16.2 defines the strict boundaries where free speech ends. It explicitly excludes three things: propaganda for war, incitement of imminent violence, and advocacy of hatred that is based on race, ethnicity, gender, or religion, and that constitutes incitement to cause harm. Notice how specific that last part is. To be unprotected hate speech, it doesn't just have to advocate hatred, it must also actively incite harm.
Part 4. The Constitutional Clash and the Court's Analysis. We now have our constitutional yardstick. How does that super broad broadcasting rule measure up against these strict constitutional protections?
Well, Deputy Chief Justice Langa, writing for a unanimous court, broke it down perfectly clearly. The broadcasting rule just catches way too much speech. Clause 2A does not require the broadcast material to advocate hatred. It doesn't even require that the material have the potential to cause actual harm, and because of that, it prohibits speech that is actually fully protected by Section 16 of the Constitution. The net is just cast far too wide. Not every single statement that might say prejudice relations amounts to propaganda for war or incitement of violence.
Now, you might be wondering, why does this matter to me? Well, consider the number 30. That is the maximum number of days a broadcaster could have their license suspended for repeated violations of this rule. The court emphasized that radio and television are hugely influential media. If a broadcaster is terrified of losing their license for 30 whole days just because they air a controversial yet constitutionally protected opinion, what happens? They're going to self-censor. It creates a massive chilling effect. And remember, free speech isn't just about the speaker's right to talk. It's about your fundamental right as a citizen to receive a wide diversity of views and information. A broad, vague rule like this directly infringes on the media you consume every single day.
Part 5, the final verdict and the remedy. Okay, so the Constitutional Court determined this broad clause was an unreasonable limitation on freedom of expression. But does that mean we just delete the rule entirely and let broadcasters say absolutely whatever they want, no matter the damage?
Absolutely not. The court recognized they couldn't just strike the whole rule down and leave a dangerous regulatory gap. South Africa is a diverse society with a history of laws that actively encouraged hatred and fear. The government has a constitutional duty to regulate broadcasting in the public interest to protect human dignity. So the court used this highly precise legal scalpel called notional severance. Instead of throwing the whole rule in the trash, they essentially sliced it in half, separating its application to protected speech from its application to unprotected speech.
Here is how this legal surgery actually works in practice. First, the court declared that the broad phrase prohibiting material likely to prejudice relations is invalid, but only insofar as it applies to speech protected by the Constitution. Second, they explicitly ordered that the rule remains perfectly alive and active for any broadcast that falls into the unprotected categories. This means broadcasters still cannot air propaganda for war. They can't incite imminent violence, and they can't advocate hatred based on race, religion, or gender that constitutes incitement to cause harm. It's a brilliant balancing act, really. It protects human dignity and equality while strictly preserving that all-important right to freedom of expression.
And that brings us to the end of our explainer. The Constitutional Court provided this amazing guiding principle, but they actually left the final judgment of Dr. Zaki's specific broadcasting to the Broadcasting Monitoring and Complaints Committee to decide, using this newly clarified constitutionally sound rule. It really leaves us with a profound thought to ponder. In a democratic society, who actually decides where free speech ends and harmful speech begins? It's a fragile, delicate balance, and it's one that requires our constant, focused attention. Thank you so much for joining me to unpack this fascinating case, and I will see you in the next explainer.